Hello friends, we the Swatantra Legal Advocates are again back with a new topic. This time we will discuss about the notices under service tax. As all of us know that since last 2 to 3 years we are getting many notices under service tax after the introduction of GST regime. Even in current period, various show cause notices issued under service tax, they are pending for adjudication, or where the adjudication order has been passed, they are at various stages of litigation. Might be commissioner of appeals or might be tribunal. Now if we see, the major trend in the service tax notices is that the service tax department has been issuing notices on the basis of data received from income tax department. To put it simply, they have simply analyzed the data which is received on the basis of income tax return filed by the assessee. If they are able to see that in the turnover details, if the taxpayer has shown that he is providing services, and if they find that either the taxpayer is not registered under service tax, or the turnover shown by the taxpayer in the service tax return is less than the turnover shown in the income tax return, then without making any further analysis, they are simply issuing the letters first and then the show cause notices. Majority of these show cause notices were issued during COVID period, that is 2020-2021. At that time, as all of us know, the majority of the business operations were halted. People were not able to carry out their routine business operations. So the matter of responding to such notices and receiving such notices is almost impossible. So what happened actually? These notices were issued by the department, as I already told, simply on the basis of ITR data. And the provision under which these notices were issued was proviso to section 73 subsection 1 of chapter 5 to the Finance Act 1994. Now chapter 5 of Finance Act 1994 deals with all the provisions regarding service tax. Now what is mentioned in this proviso to section 73(1)? It is simply mentioned that whenever any service tax is short paid or not paid due to fraud, due to suppression of facts, due to misstatement of facts, or due to contravention of provisions of the act in order to evade the tax, then only notice can be issued under proviso to section 73(1). Now, one important point to be noted here is that whenever any officer wants to issue the notice under proviso to section 73(1), he needs to first establish that there is an attempt to evade the tax by the taxpayer, either by way of fraud or by way of suppression of facts or misstatement of facts. In majority of the cases, these type of notices are issued on the ground that the taxpayer has either suppressed the facts and or has contravened the provisions of the act in order with an intent to evade the tax. So simply by mentioning in the show cause notice that the taxpayer has suppressed the facts or he has contravened the provisions of the act with an intent to evade the tax is not sufficient in order to make these notices legal. Simply on the basis of data received from any other department, they cannot issue the notices under this particular provision. Why they issue the notices under this provision? Because they can extend or they can invoke the extended limitation period of 5 years from the relevant date or from the due date of the filing of the return for the service tax. If the taxpayer is registered, then from the due date of the filing of the return. If taxpayer is not registered, then from the relevant date. So more or less this period is 5 years. Since the department was not able to do all these things within the time period, which was only 30 months, that is 2 years and 6 months from the relevant date, what they could have done, they could have obtained this data from the income tax department. They could have issued the notices to the taxpayer inquiring about the facts of the case whether he has filed the return, why he has not filed the return, what is the reason and all. They could not do all those things in that period of 30 months. So the moment they received the data from the income tax department, instead of making any further inquiry and instead of taking so many efforts, they have simply invoked the extended limitation period of 5 years and issued the notices. So the one thing that we need to understand, merely on the basis of data received from income tax department, without making any further inquiry, you cannot issue the show cause notice. So in all these cases, even though you have received the letters before issue of show cause notice, but the date of issue of show cause notice is very important. If it is after 30 months from the relevant date, then that show cause notice issued under such circumstances, that is without making any further inquiry, without having any material in their hand except the data from the income tax department, all these show cause notices are illegal, invalid. They are a nullity and they are illegal right from the beginning. So once the show cause notice is invalid, all the proceedings that took thereafter, that is hearing, then submission by the taxpayer, passing of the order by the department, or even passing of the order by commissioner appeals, all those proceedings are totally illegal. So my friends, you do please keep this particular point in your mind, so that you can challenge the notices, right? You can challenge the root of these notices and you can get the required relief for your taxpayer. I hope this is important information for you, and it will be useful for you. Thanks a lot for your patient hearing. Bye.